Good afternoon, everybody. How's everyone doing? We'll wait another minute or two, and then we'll get started. Someone would just put in the chat that you guys can hear me, just so I know it's working. All right, we had about 25 people register, so I'll probably be some people who trickle in. We'll go ahead and get started just to respect everybody's time. So thank you all for taking time out of your day. Excited to do this. It's probably going to be a kind of monthly educational sessions that we're going to start doing. But this first one is about PI attorneys, about working with disabled clients. So I know a lot of people on the call or who registered, and we'll be sending this out to work with disabled plaintiffs. So let's get started then. Okay, so name of the seminar, name of the webinar, what PI attorneys need to know about protecting themselves and their clients when representing a disabled plaintiff. Probably be about 30-40 minutes. If you all have questions, put it into the chat box. We'll try to get to them. If not, I'll send you all an email and answer them after the call. But so, if you all don't know me, my name is Justin Stivers. This is just, kind of bullet points about me. But, really why this webinar, why I feel, I guess, qualified to teach something on it and why I know a little bit about it is because, my practice in the probate world and on the estate planning world deals a lot of times with individuals who have been in a catastrophic injury. Something horrible has happened. There might have been a death, or there might be a severe injury, and now the person has hired a personal injury attorney, which is not me, but they've hired a law firm, they've hired a personal injury attorney to bring a lawsuit, right, against somebody. Often those lawsuits result in large settlements, right? Multi-million dollar, $1 million, even several $100,000 verdicts. And, this is important for, PI attorneys. If you've been doing it for a while, you're probably familiar with it. If you're newer to the space, it's maybe not something that you've thought about, but a lot of times these individuals who are receiving money or who will be receiving money are going to have some sort of public benefit, right? And we're going to talk about the different types, Medicaid, SSI, and all of that. So in my space, in the probate world, or even in the estate planning, this comes up all the time because I'm going to be drafting a special needs trust, a DC4A trust, and I'll talk about those different types of things because we want to make sure that, hey, good, we got you $1 million settlement, but if you're a quadriplegic, you're going to have a lot of medical expenses the rest of your life, and that $1 million might not cover it. And so if we give you $1 million, you might lose your benefit. So this is something that I deal with, on a regular basis. And if you're, again, in the PI space, personal injury space, it's probably something you're going to come across pretty regularly as well. So simple stuff, we're all familiar with the Zoom thing. Like I said, we'll probably be here 30-40 minutes, short and sweet. So, try to pay attention, turn off the email notifications and whatnot. And like I said, if you have any questions, write them down and we'll try to answer them as we go along. So what are we going to be talking about today? We're going to talk about who is a disabled plaintiff. Second, we're going to talk about, an overview of government benefits that a disabled plaintiff might be receiving or entitled to receive. Third, we're going to, review what your potential liability as an attorney, if you fail to address those issues and protect those government benefits. Some case studies and some cases that have come out that might scare you a little bit. Next, we're going to talk about the options in settling a case involving a disabled plaintiff, some things that you will want to do and some options that are available if you are, again, working with a disabled plaintiff. And then just some things that myself and my office does and how we could, hopefully be of service if the need comes up. All right, so who is a disabled plaintiff? And so this is the federal regulations dealing with SSI and Medicaid, defines a disabled person as an individual that has a severe medically determinable physical or mental impairment that is expected to last at least 1 year or result in a disabled person's death. In addition, the impairment must result in the disabled person being unable to engage substantial gainful activity. Okay. So one major category available to disabled plaintiffs are known as entitlement programs. And so you've probably heard of these, most common being Social Security Disability and Medicare. So to receive Social Security Disability, a person must be disabled as defined as the federal regulations, which we just talked about. Under the retirement age for Social Security retirement benefits, this is a little bit technical, but have at least 20 credits in the 40 quarter period, which is basically 10 years. It's known as the 20-40-40 rule, essentially. And a determination would be made of whether the plaintiff meets this requirement by checking with the Social Security Administration. And they have to be disabled for at least 5 months, meaning that you would not be getting your first payment until after 5 months of your application being approved. So another method of obtaining Social Security disability is where a child becomes disabled before the age of 22, in which case the child might qualify for Social Security disability based on the record of a disabled, deceased, or retired parent. But the child would only be entitled to this benefit, which is referred to as the childhood disability benefits or disabled adult child, for as long as the child remains disabled and unmarried. That's the first entitlement program. The second one is Medicare. And so really, Medicare is only available to seniors who've paid into the Social Security system, but it could be available to a disabled person after they've been covered under Social Security for 24 months. So eligibility for entitlement programs is not what we would call an asset test, an income test, or for the disabled plaintiff. So there's the possibility that these will come up for the disabled plaintiff, but really what we're talking about in terms of benefits and making sure your disabled plaintiff is protected and protects those benefits is going to be a means government tested benefit program, which we're going to discuss. So in this, for entitlement, as far as Social Security, Medicaid, Medicare, probably not as big of an issue, but still potentially an issue. So these are the means tested programs that are going to come up. Supplemental Social Security Income, or SSI, Florida Medicaid, and it's really just called Medicaid. I kind of referred to it as Florida Medicaid, but it's a part of the larger just federal Medicaid program. In-home supportive services, or IHSS, subsidized housing, commonly referred to as Section 8 housing, and temporary aid to needy families. But kind of in the interest of time, I'm just going to talk about the first two, SSI and Florida Medicaid. But again, if you're dealing in this space at all, or you need to be somewhat familiar with the entitlement programs if your disabled plaintiff is receiving benefits under any of these ones. All right, so why is it important that you, again, if you're working in this space, have some knowledge of entitlement programs? So it's important because the receipt of litigation proceeds by a disabled plaintiff who's receiving those benefits under any of those means tested programs is going to cause disqualification from the program until the disabled plaintiff has spent the litigation proceeds down, where they're going to qualify again for those programs. And usually that is going to be down to $2,000. And so most of, really probably all of the settlements, any verdicts or anything like that are going to be much more than $2,000. And so if you're, again, giving a plaintiff $1 million, it's going to automatically disqualify them for these means tested benefits. So loss of some eligibility for some programs may not be critical if the disabled plaintiff has reached a large, settlement amount, but in many circumstances, it's crucial that they continue maintaining eligibility for Florida Medicaid, because it's really going to be the only health insurance coverage that's available for them. And what I mean by this is, if they're getting $100 million, right, they're probably going to be able to self-fund their medical care. they're not going to necessarily need to structure their money in a way where they're not going to have immediate access to it for the sole purpose of protecting their benefits, because $1 million is probably going to cover any of their, $100 million is probably going to cover any medical expenses they have. But again, it's $1 million. If it's less than that, depending on the types of injury, the severity, and all of that, they will want to protect them. So supplemental security income, SSI, it's available to individuals that are 65 or older, disabled, a U.S. citizen, not a resident in a public institution, has no more than $2,000 in countable assets, and meets the income guidelines, which I'm going to talk about here in a second. So what are countable assets? What does the government look at to see? Here's a list of them: cash, savings accounts, stocks and bonds, annuities, real estate other than the primary residence, and more than one car or any type of recreational vehicle. Again, important to note, proceeds from a litigation are going to be countable assets. So they're going to put that when they're determining whether your client qualifies for Medicaid or SSI. Assets that are not going to be counted. So again, your primary residence, one car, household goods, personal effects, a burial plot, prepaid funeral. All right, this gets a little, next couple slides are a little bit technical, and this is just kind of meant to kind of show you the complexity, but also kind of show it's really not a lot of money, which is why, I see clients sometimes or work with PI attorneys, and it's a relatively small amount, relatively speaking, $50,000 or something, and that still could greatly affect their benefits. So the maximum monthly benefit to an unmarried person on SSI is $794. A married couple can get as much as almost $1,200. Some states, such as Florida, include a state subsidy that would cause the actual amount to be a little bit greater than these numbers. But the maximum benefit is going to be reduced if the SSI recipient receives income. And so again, this just kind of says what income is, defined as anything received as cash except for the first $20, which is exempt, and then the first $65 of earned. So I won't get too much into that because again, it's technical, but as you can just kind of see here, you're potentially talking about $1,600 for an unmarried person a month, $2,400 for a married couple. So we're not talking about a lot of money. And so again, a $50,000 settlement could really mess them up. And when you're dealing with a spouse or a minor that lives with a parent, you need to be concerned about deemed income, because the minor, the spouse, if the income, the income of the spouse or the parent is treated as this disabled parent's income, even though earned from another family member. So you see a lot of this where minor children, living with their parents, the parent's income could be construed as their income. So in addition to the receipt of income, as we discussed, in this past couple slides, you need to be concerned about in-kind support and maintenance. And so what I mean by that is, just broadly speaking, is food and shelter. So when the disabled beneficiary lives with someone and receives food and shelter as part of their arrangement, the disabled beneficiary's monthly SSI payment is going to be reduced by up to 1/3. And so this is known as the 1/3 reduction rule, or VTR. And so it can basically be as lost as much as $265 per an individual per month. So again, not a lot of money. Where an SSI beneficiary receives in-kind support and maintenance other than part of the living arrangement, then this is what's called the presumed maximum value, or PMV rule. It just calls for another reduction in the SSI beneficiary payments. So again, just finding more ways to reduce the amount that clients can have in their accounts. All right, and then last kind of piece on this, and so it's a little bit older, but since 2005, federal regulations changed, so clothing is no longer counted as in-kind support and maintenance. All right, so that's SSI and how the litigation proceeds can cause ineligibility to receive those benefits. Let's talk a little bit, now about Florida Medicaid. Again, or you can just call it Medicaid. And there's, depending on the state that you're in, most of you all are probably going to be in Florida, but some of you might be in other states. But depending on the state that you're in, they have eligibility criteria for providing Medicaid. So I'm going to talk, briefly about that. These states, which you can see on the slide, these are what we call 209B states, and they have at least one eligibility criteria that's more restrictive than the SSI program. The SSI program being the federal. So these states are going to have more restrictive: Connecticut, Hawaii, Minnesota, Missouri, and the rest of the states that are on there. SSI states use the federal SSI eligibility criteria for determining eligibility for Medicaid, but a state agency, also can make its own eligibility determinations. And so fewer states have their own determinations as well, and these are the ones. But the majority are going to be what we call 1634 states, and they use the SSI eligibility criteria for determining Medicaid, whether or not you're eligible for Medicaid. And so they've entered into an agreement with the Social Security Administration that if you're determined eligible for SSI, then you're going to also qualify for Medicaid as well. And so Florida is one of those states. So Florida is a 1634 state, meaning that if the disabled person here qualifies for SSI, they're automatically going to qualify for Medicaid. All right, as I mentioned, Florida Medicaid coverage is critical for many disabled plaintiffs because it's going to be the only health insurance coverage available to them. Medicaid is going to provide inpatient, outpatient hospital services, physical, physician services, physical therapy, prescriptions, skilled nursing home, community care, personal care services, a whole list of things. So really important. A lot of your clients, they might not even be on Medicaid at the time they come to you as a client, but they will be trying to get onto Medicaid. And so that's an important part of when you're kind of doing your due diligence, find out where they are in terms of that. Because again, that might be the only healthcare available to them. All right, so what happens if they lose their benefits, right? So here are a couple scare you cases. If you fail to protect the government benefits for your disabled plaintiff, that they are receiving or that they would become eligible to receive, but for the money that they're going to be receiving from your settlement or your verdict. So this is all these cases are a little bit older, but still relevant. This is the Grillo case out of Texas. It's a 2004 case. And so a disabled plaintiff settled her case on the advice of her PI attorney. She later sued her PI attorney and the guardian ad litem for malpractice for failing to consult with experts that could have structured the settlement that she got and would have preserved her government benefits, given her tax benefits, and ultimately preserved her injury settlement from dissipation. Because what happens is if you lose your benefits, right, now all that money that you got in that settlement is just going to be paid for medical bills. And as you all are probably aware, those medical bills can be astronomical. And so that basically just depletes everything that you got from your settlement now goes to them. And so this case settled against the PI attorney and the guardian ad litem for $4.1 million. What's interesting is I think the guardian ad litem was the one who paid the bulk of that. So Saunders case, Department of Social Services v. Saunders. There was a conservator. Florida, we actually used the term guardian, but conservator settled a personal injury action on behalf of the ward, on behalf of the disabled person. And so as part of the compromise and to settle the claim, the conservator requested that the settlement be placed in a D4A litigation special needs trust, which we'll talk about what that is here in a second. But they wanted the money to be put in a special needs trust to preserve the ward's benefits, the government benefits. And the state of Connecticut objected to the use of that. They wanted that the ward spend down the money, spin down the injury award, pay back these medical bills. And the Supreme Court of Connecticut held that, this is a quote, by failing to establish a D4A litigation special needs trust, the probate court and Saunders could be deemed to be in dereliction of their duties to the ward. So Connecticut Supreme Court basically said if they hadn't done that, they're going to be potentially liable. So here's, I think, last one. In 2000, an attorney was retained to draft the will that left a significant amount of money to the person's sister, so to the testatrix sister, the person who was drafting the will. That person was residing in a nursing home and was receiving Medicaid benefits. So after the person died, the sister received the inheritance that was left to her via the will, and she was ultimately disqualified from continuing to receive Medicaid benefits. And so the Supreme Court in Maine held that the drafting attorney could and should have used a special needs trust for the sister in the nursing home, knowing that she was on Medicaid, and that the failure to do so was ground for suspension, and so got their license suspended. So, it happens, right? And it's just, that's why it's just very very important to pay attention to. So it's a complicated area of law, right? So determining how best to preserve the assets for a beneficiary is going to require knowledge of a bunch of different things. So I just listed them here. Social Security Act, Code of Federal Regulations. We've got just the federal rules, and then we've got the Florida specific rules, Florida Administrative Code, Administrative Register, Probate Code, so rules of civil procedure. And so, I think most people would agree, kind of want to stay in your lane as much as possible. And so, if you're a PI attorney trying to learn all of this, could potentially be overwhelming for you. But so what are some options that might be available out there? And so the first step in determining how to proceed with settlement negotiation is determine whether the plaintiff is a minor and or disabled. And so if this is a case where a court proceedings going to be necessary to compromise the claim. So one option might be for an outright payment to the disabled plaintiff, the guardian, or the custodian, right? But in doing so, it needs to be investigated whether the settlement proceeds can be spent in the month of receipt or invested in an exempt assets. Otherwise, they're going to lose government assistance. And so you also want to be concerned about the mismanagement of funds by the parent, the guardian, or the custodian. This one, though, is really limited because depending on the amount, generally in Florida, it's $15,000. You can't just give more than that to the parents of a minor child. It's usually going to have to be structured somewhere. But again, depending on the amount, and again, even if it's $15,000, remember you've got to have $2,000. You can't have more than $2,000 in your account at the end of the month, or else you might be disqualified. But this, depending on the situation, could be an option. Another option might be what's called a blocked account, but very rarely used, and just throw it on here as an option. This is going to be a popular one, a lot of very popular with the personal injury world. So a structured annuity or a settlement. And so this is going to offer the benefit of a guaranteed income stream to the disabled plaintiff, certain tax benefits, and professional asset management. Those are the good things, but it's a little bit inflexible in that the funds get locked up. There's not going to be a pool of assets that can be used by the disabled plaintiff for getting a new house, expensive equipment, medical treatment not available for Florida Medicaid. And depending on the age, a lot of times these terminate at a young age, at 18, 21, or 25. So again, if you're leaving $3 million to a minor child, you might not want the minor child getting that money at 18, at 21. But this is definitely an option, and usually a good option. But this is another really great option. And so maybe one of the best is doing what's called a D4A litigation special needs trust. And so this trust is authorized under federal and Florida law, is only available to disabled plaintiffs under the age of 65. And so by paying the settlement proceeds into the trust, the disabled plaintiff's not going to lose their government benefits. The trust assets can be used to supplement any benefits provided through the government assistance programs. And then what's great about this is after the death of the disabled person, in Florida, we have the Florida Agency for Healthcare Administration, ACA, which is kind of the Florida Medicaid. They'd have a priority claim against the money that's left over to get repaid for anything that Medicaid paid. But after that, any money that's still in the trust could go to the person's beneficiary. So to break that down, one more time. You've got the special needs trust. You've got $2 million. It goes into the special needs trust. The child, the person under the age of 65, isn't going to lose their benefits. Their benefits are still protected because they can't just go to the trust and say, hey, give me, $500,000 so I can go buy a new car or whatnot. But the trustee, the company that's holding the money, does have discretion to pay money to this person to supplement their Medicaid if they have more medical expenses that maybe Medicaid is not going to pay. They will buy a car, they will buy a house. So it gives a lot of flexibility. And again, if the person dies and they still had $1 million in that trust account, after Medicaid gets their money back, that whatever's left can get left to their beneficiary. So often what we'll do is when we're drafting the special needs trust is we'll put in there, we might do a supplemental will or a supplemental revocable trust, and we'll say reference my estate plan, reference my revocable trust, and that will be how they want whatever money's left to be distributed to their beneficiary. So it's a really great tool. This is what I see a lot of, though, is combining a structured settlement with the use of a D4A trust. So this way you get the liquidity and flexibility of the trust, but you're also getting a predictable income stream from the annuity, from the structured settlement, and you get the tax advantages over and professional management over the asset. So that's a great option. All right, so I think with that, okay. So an attorney, this is probably not going to be something that you're going to do yourself. The trust only should supplement what's being provided by the government agencies. Representatives of Social Security Administration in some areas of the country have denied eligibility where the trust did not contain the proper discretionary language, or where the trust was not created by a parent, grandparent, or guardian. So there's certain language that has to be in there. Not anybody can create the trust. And so this is really where, again, kind of stay in your lane sort of thing. So similar to D4A, this is a D4C trust. All right, very similar, except that if you remember the D4A, you had to be under the age of 65. The D4C is not limited to a disabled beneficiary under 65. And so two important differences about these trusts is that this one is going to be administered by a nonprofit agency that deals with issues related to the disabled. So it's a nonprofit that's managing it, and any money that's left, right, is not going to go to the person's beneficiaries. This is any trust assets that remain are going to be paid to the agency to get paid back. And they're going to be paid to the agency to be used for the benefit of other disabled beneficiaries. So you don't really get the freedom to say, hey, when I die, I want this money to go to these people. It kind of gets put back into a pooled trust that's going to help out other disabled plaintiffs. Okay, so a couple things on how we can help. How working with an experienced estate planning attorney can kind of benefit you if you're working in this space. So often I'll participate in maybe a pre-settlement conference to determine the types of means-tested programs that your client is receiving or might be entitled to receive. We might assist in determining the amount of secured medical claims or the amount of the liens that would be needed to be repaid to Medicaid or other state agencies. We can help you determine whether the medical providers or state agency would be willing to negotiate a reduction in the amount of the liens or the claims, and then discuss options as to how to structure the settlement so that you don't lose government benefits, right? That's the main thing. So get us involved. We're getting a state planning attorney involved in the negotiations so that you want to know how much potential medical bills are going to be owed or is going to be owed in the future. That's going to help you determine how much the settlement amount should be, right? If you know that there's going to be a lot more medical bills coming in, you want to make sure that you plan for that when you're negotiating the settlement. Again, just the type of settlement, right? Whether we're doing a D4A, D4C. And then if it, a lot of times, this is probably a large part of what I do is going to the probate court and getting the settlement approved, right? And so often we're going to have to open, again, if someone has died, if someone has passed away, we're going to be open up the estate so that the injury lawsuit can proceed or so that the settlement can be approved. Sometimes they will get, you all might get the cases settled in civil court, but a lot of times the case is going to be settled in probate court or the guardianship court, depending if it's a minor. And so that's a large part of what we do. And some agencies will try to fight us on this. And so again, just having the experience to go and say, hey, no, these are the laws. This is why this money is protected. It doesn't all need to go to pay back all expenses, all bills and whatnot. Let me see what else here we have. All right, so after the D4, after it's been put into a trust, we could potentially help with advising the trustee as to the aspects of the trust administration or subsequent distributions, or provide periodic accountings, or again, acting as attorney for the trustee. So kind of ran through that, but said 30, 40 minutes. So, I think one of the main things that I see is you just want to start the conversation soon, right? Start the conversation very early on with your client, with your prospect, because there's a lot of it, even once you receive, I didn't talk about this, but I've seen some issues where if you've already received that money and it's in your trust account and for all intents and purposes, it's been settled and that money could go to the client, you could be getting yourself in trouble. So you want to plan on this well in advance. You want to know, again, what the client's medical concerns are going to be now, but also in the future, so that you can plan properly for the type of, for the amount that you're going to be negotiating or requesting from the jury. But where is that money going to go? And a lot of clients, they're might not be sophisticated, right? And they just think they're going to get $2 million and they're going to fight you on this. They're going to say, hey, give me my $2 million. And I've seen that happen. You just want to, CYA, right? Have the client, you advise them, document it very, very clearly all along the way. Hey, we advised the client, we had them meet with these professionals. We told them they were going to lose their benefits. They signed off on this so that, a year, 2 years down the road, they don't come back to you and say, hey, you gave me all this money and now I spent it on Medicare or on Medicaid, my medical bills, and I don't have any money left. So just something, again, you want to start very early on and just keep documenting it. And right, in a lot of those cases that I mentioned earlier, the court brought up, hey, we didn't see you doing this along the way. And so that's something that you want to do. But I think that's it. So if you guys have any questions or interested, or if I can help in any way, we've got our contact information up here. Would be happy to help. I'll send, again, I appreciate you all showing up. Next month, I'm going to be doing one on transferring real estate into trusts. And so if you all are interested, I'll send you all the links for that. But again, thank you guys for showing up, and have a great afternoon, and we'll see you soon. Thank you guys. Take care.